Good morning, Mr. McLaughlin.
Good morning, Your Honors. And may it please the Court, Robert McLaughlin Sr., and with me my partner, Michael Eby, for all of the defendants who are the move-ons under the, for a special motion to dismiss under the anti-SLAPP statute. May I say at the outset that this case involves truly access to and limitation of access to a government building, the so-called Exhibition Center, the BCEC, created by the legislature, and by the legislature given control to the so-called South Boston Foundation, which my brother continues to say, and indeed the appeals court even said is a private charity. It's not private. I'll get into that at some length. It's public, and it's not a charity. It's defined in the statute as a committee.
Mr. McLaughlin, this is a very small point, but let me just ask you, given what you just said, and I don't know if you've looked at the definition in 30A, 11A and a half or whatever, but wouldn't you think that in fact the open meeting law does apply to this committee?
I don't think it really does. It's a good question, but I don't think it makes any difference.
It doesn't. But it's a point that Mr. Cooper makes. It seems to me it could well fit into that definition. As
everyone has said, this is an inartfully drafted statute. It is unclear even who has voting rights, if it's the designee of one of the petitioners, whether there's a quorum when they meet at Mull's Diner. There are 100 questions, none of which I think are relevant, because I think you can go to your building inspector in town and you're petitioning government. So,
what is the difference between the foundation here and some of the authorities? The authorities are clearly governmental agencies, so I'm asking you what's the difference between the authority and the governmental the authorities that are governmental agencies?
Well, I think you look at what is government, which is the fundamental question. This foundation was carrying out clearly a governmental purpose. It was to take funds, and it was to distribute it in its discretion to those who were impacted by the authority. It's a creature of the legislature. Political appointments, all of them, including the senator, the representative, and it's, I think, well known, a certain amount of deference in the legislature to a local issue. These are the three people that really the legislature is going to listen to. That was the thinking.
Well, may I just interrupt? Was this also a 501c3?
It was, as I understand it.
Well, isn't that a charitable organization?
It may be, and why they went and chose to create a separate entity. And apparently,
is that in the record anywhere?
I don't know if that's in the record, but then my brother can speak to it. My understanding is they did, in fact, create a separate entity. They were created by the legislature. There's no reason for them to create a separate entity. Now, presumably to stay in good graces with the Internal Revenue Service, because they were really, I would say, unrelated business income. If they were going to run a boat show, they were probably outside the charter.
The money goes to uses cited by the legislature, correct?
Yes, absolutely.
So it's very much like an authority. It's essential. It's essential business is governmental.
It's using a government asset.
Right.
It has control of at least 3 days or 3 shows of a government asset.
Then the question becomes whether this is petitioning activity. Now it's commercial speech, and does that make it not petitioning because it's commercial speech?
Well, I hope not. As Judge Greene has said in the Office 1 Lopez decision, that the broker in that case, Lynn Moore, was petitioning purely for economic self-interest. There's nothing mutually exclusive between commercial speech and petitioning. All kinds of corporations can petition government.
Well,
so that's I think
lobbyists. That's what they
do. Absolutely, and indeed at the petitioning level, the Fabra versus Walton case, the motive for the petitioning is irrelevant, absolutely irrelevant. So that indeed, I just don't think that it's any particular distinction. Most cases, somebody, the widow of the firefighter, she's looking for a pension. Most people are trying to protect some kind of an economic or pecuniary interest when they are petitioning government in many of these cases. So I don't see as any mutually distinctive there. On that issue, the Cradle case is clearly, my brother relies upon so much, clearly distinguishable. There are findings of fact by a judge not to be set aside unless an abuse of discretion, that the website was set up for commercial purposes, that he wasn't seeking any redress for government. He may have been petitioning the banking commission or something, but that's not what he was sued for. He was sued for what he put on his website. The actual challenge statement was the defamatory statements about Cato in his website. And as the court held in that, aggressive lawyering is not protected petitioning. There was nothing pending at that time, as opposed to this situation, when the bill to amend the statute, which would allow, and this was the second bill that North America had tried, the so-called, if the previous venue has refused.
4153, is that the one?
I think that's the number, Your Honor. That was pending throughout the entire time. That's referred to when my client, Mr. Corcoran, is there at the association. What do they say to him? They say to him, there's a bill pending. You may have a monopoly now. You're in the catbird seat now. What if it's changed? And he's standing his ground. That's petitioning. And let me say, if I may for a moment, I serve on a building committee in my hometown. If we had a low bidder we were about to give a contract to, and the second bidder came in and challenged it for irregularity, we gave it to the second bidder, and that first bidder sued him for coming to us, he'd absolutely be dismissed as a slap suit. Where do you come to when government is about to be abusing your rights? It's the foundation that was given this authority, albeit he didn't go to the foundation, they called him. But he went to that foundation and he stood his ground. You can't do this. You can't squeeze a for-profit boat show into a charitable immunity. That's petitioning government to the authority that had the particular jurisdiction to deal with this matter.
Mr. McLaughlin, let me ask you about some of the other counts. I mean, what you're talking about is, if I have this right, is sort of counts 1 and 3 of the complaint. But the Superior Court judge dismissed all of the counts. And as I read your brief, some of the arguments you were making didn't have to do with SLAPP. They had to do with that these counts, like the 93A or something else, was dismissible for reasons other than petitioning.
Maybe we rose to the bait, but let me say, the declaratory judgment, as we cite in our brief, there's no such thing as a declaratory judgment in the abstract. The only reason the declaratory judgment was brought was because we were there petitioning and taking the position that the foundation couldn't do this. And indeed, it was a sham. They didn't name the necessary parties and so forth.
Well, that may be, but that's my point. It may be dismissible, but for reasons that aren't necessarily related to Section 59H.
I say this, Your Honor, I do think they had this common nexus, which is what was going on at this time, and to try to, because we were there and because we were petitioning. May I also say, under Wenger, which came down in March, if that count survives, the SLAPP doesn't go out. They're clearly separate. So, but I don't think that count should survive. The good faith and fair dealing. What does it say? I mean, they took their shot at us in 2001 saying, you should have given us an extension. As I read the good faith and fair dealing, I look for it in the pleadings. I don't see it in the pleadings, but I see in their brief that they're again looking for some sort of an obligation to extend the licenses for a further period of time. These licenses just came to a conclusion at the end of their term.
But that's not SLAPP. That's all I'm saying.
That's not SLAPP, but I hope they can't defeat SLAPP by throwing in absolute bogus counts. The language of the statute in the cases, Your Honor, is no other substantial basis alone, and no other substantial basis. The declaratory judgment wasn't substantial. The good faith count wasn't a substantial other claim. They really came after us. The motivation, if I may say, and there are so many cases, and you read them, and they seem to be inconsistent because I think the courts have been focusing on who's doing the petitioner. Is it the lawyer? Is it an expert witness? Who is being petitioned? Is it Blue Cross? Is it FDIC? Where the focus should be is what was the purpose of this statute. Purpose of this statute is when a citizen somehow or other is bumping into government, whether he's a corporate citizen, whether he's an individual citizen, whether he's motivated by greed, it makes no difference. When he's dealing with government, why was the lawsuit brought? That was the evil that was intended to be dealt with. And that evil in this case was we were bumping up against government when the competition, my brother will argue we're nothing but competitors. Well, we were competitors, but not in the marketplace. In the legislature is where we were competitors. And when we began to assert ourselves, 2 days before this suit was brought, if you study the record, and you look at the Corcoran affidavit, he says 14 days before, I met with elected officials. We were sued 2 days later. And the form of the injunction was completely to blanket us from doing anything, even going to a legislative hearing that we didn't know about that was scheduled on July 18th. That's why the suit was brought. That's where the SLAPP statute ought to be focusing, rather than getting lost in the definitions, but look to the nexus. Why did somebody bring this lawsuit when somebody was trying to do something in government? It's the intent. They make the absurd statement in page 6 of their reply brief when they see this as the argument, that the intention of North America does not apply. That's not the law.
Can I ask you another question?
Yes.
The question is this: in terms of the motion to amend with the claim about, I'm going to get the initials wrong, MMTA, do I have that right? Or
The Massachusetts Maritime Association, I think they
as I understand what you're saying, it's that you think that what the representative of MMTA testified to at that secret hearing was wrong, and that your response that is being challenged in that proposed amendment was, I guess, part of somehow responding to that legislative hearing. I'm just not clear how you get that into the slap.
They went and they said, we refuse to do business with North America, and that's not so. What we did was we went nationwide with a request for proposal, including to North America, and when they sent us a terrible response, we said, is that what you want us to rely upon? And we were in the process of looking for who to put a boat show on. In fact, even with another national boat show, people who were also talking to the foundation, who is a bit of an aside. But when the association went and said they refuse to deal with North America, and this is important to our industry, Corcoran, as his second affidavit says, he went to those members of that committee and said that's not so. He said in substance what I just said. And then he wrote a letter to the Maritime Association telling them that. And I suggest if that isn't mirror image, if that isn't closely and rationally related to the most pure form of petitioning appearing before a legislative committee, then I don't know what is. I mean, I think that is petitioning on steroids. There's another reason why that amendment shouldn't have been allowed. For the tort for interference, you've got to have the existence of a contract, you've got to have the interference, got to be malicious or improper, and it has to be damage.
Yeah, but the court didn't say why. It just said...
They didn't say, but they didn't state a claim. It would have been dismissed on 12b-6. There was no damage. There hasn't been any damage and never will be any damage because of the legislative change which now allows it. So that Judge Van Gessler was absolutely proper. It was futile to allow that motion to amend. So,
you don't have to use up all your time.
Well, I certainly haven't looked at my argument, but I certainly have covered a lot of it. They say there's no reference in the record that they were behind all this legislative. There are at least 6 references to it. The very complaint itself it claims that the interference, and the memo also says the interference is dealing and discussing the act. I say the breadth of the injunction. Plant and Wiley, I want to say, you don't have to petition government even directly if the foundation is not a governmental agency. In that case, one lawyer writes to another lawyer. The other point is, there's an imperfect record. The purpose of the SLAPP statute is to quickly get rid of these frivolous cases. And you really don't have like a summary process record. And the courts have said, or you have said, Your Honors, please, that you give deference to the findings of fact by the trial judge or by the motion judge. The findings by Judge Van Gessler on this is unabashedly political. Bayside aggressively touted its petition before the legislature, the BCEC Foundation, and elsewhere. That's a finding of fact. That's not an error.
But you didn't, there was no evidentiary hearing.
No,
It was
there's no
done on
evidentiary.
affidavits.
There's the affidavits. But, there's also arguments that take place before, and I don't know the answer to that. But as I say, the statutory scheme, it talks in terms of the pleadings, the affidavits. Every decision I read says we take the facts from it, and they include the findings of fact at the trial judge. I don't know what the basis of those is. But in any event, they're made. There certainly is enough evidence in this record that there was political competition between both amending the records and who we're dealing with and dealing with legislatures 2 days before we sued. There's plenty of evidence in there, and he makes a finding of fact. And that shouldn't be set aside unless clearly wrong. I have covered, I think, most of the legal fees. I'll certainly leave to the record. And on whether or not there's any arguable basis of law, the standard there, of course, is practically frivolous, Baker and Pearson. We don't have to be right when we're down there saying what the law means. We just have to have a basis. Indeed, all we said was charity is not a boat show. His consent was needed. The foundation itself, and it was said here this morning, deference is given to the administrative agency. How did they read their own act? They read their own act the way just Mr. Corcoran read the act. That's why they called him to come down. And then they said, you have a monopoly now. That's exactly what the statute said. You can't steal a show we had for 10 years before this. And indeed, well, my time is up, and I thank you for the time.
Thank you, Mr. McLaughlin. Mr. Cooper?
Thank you, Your Honor. May it please the Court, Howard Cooper for North American Expositions Company Limited Partnership. Justice Botsford and Justice Cowan, let me go back to the very beginning of Mr. McLaughlin's argument, and while I'm tempted to rise to the bait of a 12b6 argument and talk about what evils this lawsuit is truly designed to address and the fact that it's a business dispute between competitors, what really is relevant here is the scope of Chapter 231, Section 59H, and what is petitioning and what is not petitioning. And there are two basic reasons in this case, before we even get to other arguments about amendment, as to why there's no petitioning here whatsoever. And the first is, Your Honor, is this Court has held in 10 years of jurisprudence since Duracraft, and recently in the Cadle decisions, as Justice Cowan's decision in Corcoran and footnote 8 of Corcoran talks about, and even as reaffirmed recently in Wenger versus Assetto, if I'm saying that correctly. The scope of the anti-SLAPP statute is designed to protect that which is protected under the United States Constitution and the Massachusetts Declaration of Rights, namely the petitioning by a citizen in their status of his or her status as a citizen seeking redress from a governmental body for a grievance, and that governmental body is capable of providing redress of that grievance. In this case, members of the Court, the South Boston Community Development Foundation was not capable of providing redress of anything. Instead, while it is a creature of a statute, like, for example, a statute might say we're going to set up an educational committee and ask Harvard University to hold a forum on it, but Harvard University can go out and have a contract with someone and get into a contractual dispute.
You can't, at least I don't think, you can very readily divorce the fact, yes, it is set up by statute, and I hear you on that, but the fact is the statute puts on this foundation as three of its members, the three political, the senator, representative, and city councilor. So these people, I mean, I think it's unrealistic to say, well, they're wearing their foundation hat so they don't think politically.
But respectfully, Your Honor, let's talk about exactly what the statute does. First, with regard to memberships, there are three political appointees who are non-voting members. There are three people from the community who are business people. And there are three people who are essentially from the social services area.
Right.
By statute, what is created is a Massachusetts charitable trust. It is a 501c3. It's in the record at A521.
The fund is, by statute, is a Massachusetts charitable trust, but the other is a committee.
Well, Your Honor, the committee exists only by definition as the administrator of the Massachusetts charitable trust. It has no other function listed in the statute. It does not expend public money. Instead, it raises money privately as a Massachusetts charitable trust,
Does it pay rent to the BCEC when it uses it?
It does not. It does not, Your Honor. But that's not by statute. It's simply that they've been given three events that they can hold to raise private money to spend privately in the community. Importantly, Your Honor, the South Boston Community Development Foundation has no indicia whatsoever of a public fora that is instrumental in any manner to the democratic process. It doesn't hold meetings. It doesn't notice its meetings. My clients didn't get notice of a meeting. It doesn't publish an agenda. It has no rulemaking authority. In fact, it does nothing except exist to privately put on a gate show. Now, how do we know, Your Honor, that really what was going on here was not engagement of an entity involved in a carrying out a public function. We know that from Mr. Corcoran's own words, because in addition to the problem with to whom the activity was addressed, which was not a legislative, executive, judicial, or other governmental body, what was it that Mr. Corcoran said? And here it's significant, the timing is significant. The record is devoid until 1 month after this complaint was filed of any legislative activity by Bayside whatsoever. It's not in there. It's in their brief, but there's no record support for it. My clients, I'm sorry.
You're saying that, Bayside.
Your Honor, the focus.
Your client must have had something to do with that House bill.
Well, there's no record evidence of that whatsoever, Your Honor, but let's assume for the sake of argument that it's true. My client's petitioning activity is not the target or focus of the anti-SLAPP statute. What's going on here is what's within the protection of the anti-SLAPP statute is what's protected under the First Amendment of the United States Constitution having to do with Bayside's rights. They were not petitioning. Their sole petitioning activity, which they've not been sued over. They've not been sued over approaching a legislator, having a discussion with the legislator. Their sole petitioning activity, according to Mr. Corcoran's affidavit, takes place 1 month after this lawsuit is filed. What's really going on here, Your Honor, is that Bayside was acting in an anti-competitive manner in breach of the implied covenant of good faith and fair dealing obligation that exists in the nearly 20 years of license arrangements that it had had with my client. Bayside did so in a hugely aggressive way by taking a completely unsupportable position with the South Boston Community Development Foundation.
Cooper, how can you say it's completely unsupportable when the statute begins by saying charitable events?
Because, Your Honor, charitable events can go out and hire private contractors to assist them in putting on an event. It happens all the time. And what I'm saying is unsupportable is for Bayside to have gone to these people who had already established an advantageous relationship with my clients that happens in a commercial setting all of the time, and to say to them, we have veto power over whether you can do that. And to rely upon that alleged veto power, solely a statement in the legislation that is an anti-solicitation provision when it was completely undisputed that my clients had approached first the BCEC and then the South Boston Community Development Foundation to try to host their shows. Now, what had been going on here, and had been going on here for a number of years, and it had resulted in prior litigation in which there had been emails that had been unearthed showing Bayside's true agenda, which remain relevant for an evidentiary perspective, although we never got to it in the Superior Court, was that Bayside was trying to squeeze out competition. And this Court has held very clearly, beginning in the Corcoran case, as I mentioned Justice Cowan's footnote, that what's at issue here is whether the activity possesses the crucial characteristics of petitioning. Again, namely, the seeking of redress of the grievance by someone in their status as a citizen from a body that is capable of providing that redress. And the Corcoran Court said very clearly, the protection of the anti-SLAPP statute does not apply to vendors of services. That principle has been carried forward in the Cato decision, in which, indeed, there was actual petitioning activity reflected on Attorney Schlickman's website. There were letters that were published to the Commissioner of Banks. There were hearings that were held, et cetera. But the Court said there, as the Appeals Court has said here, that there was a palpable commercial motive. And we're not talking about motive in the...
Of course there's a palpable commercial motive. There always is when, lobbying. I mean, there always is.
Your Honor, Bayside was not registered to do lobbying here, nor did they do any lobbying. And by the way, and I think this is a critically important point, the South Boston Community Development Foundation is a creature of the law which covers Massachusetts charitable trusts. And that means that they're governed by the purposes for which they are created. If
you say that, but there's nothing, I don't see any reference to Chapter 180 in that, in Section 15D2 or whatever.
Your Honor, it's the words Massachusetts Charitable Trust are used in the statute. It says the committee...
For the fund.
And the committee's sole purpose is to administer the fund. Someone has to do it. It's all part, there are no other powers that are listed. And the point, I think the relevant point is that neither the legislature nor by operation of law with regard to the activities of a trust, which are governed by the express purposes for which they're created, there's no authority to make decisions or to go lobby the legislature. Mr. Corcoran didn't go to the South Boston Community Development Foundation and say, hey, I'd like you to join me and go to the legislature and clarify this statute. This wasn't the type of lobbying others to go try to seek clarification from the legislature or from a court. Instead, what he did was, and this is his own words, he says, I talked to the business people, and I showed him North American's proposal, and I said to them, do you want to do business with those people? And basically, I talked them out of doing business with North American so they might do business with me. And just like the attorney in Cadle, who had a palpable commercial motivation, which isn't important on its own, except that it undercuts the claim of petitioning activity.
I understand that's your position, Mr. Cooper. I fail to understand why it undercuts the claim. Because let's assume you're petitioning the legislature, and you have the same palpable, and I think that's Justice Botsford's question, you have the same palpable commercial, if you want to change the tax code so it goes one way rather than the other way, there's a palpable, you have no interest in having the best tax code.
The difference, Your Honor, is that when you're talking to the legislature, you're not talking to your business competitor. And in this instance, the person that Mr. Corcoran was trying to talk out of doing business was someone that he perceived as his competitor because they were doing business with my client.
No,
And-
but if, I mean, the question is, do you have a legislative body? Because let's say I am, a small business, and I'm trying to talk the legislature out of going the way of big business, and big business is in there trying to persuade the legislature to go its way. You've got the small business and the big business going against each other.
But, Your Honor, again, the protections of the anti-SLAPP statute are targeted to the right to petition, which is embodied in the First Amendment and in the Massachusetts Declaration of Rights. Those rights exist in terms of both who you are petitioning and what it is that you're saying. And my point here is, I agree, Your Honor, if we had sued, my client had sued Bayside because they had went a month later and talked to a legislator and said, we want to...
Let's take for purposes of this that who they did go to, the foundation, the charitable trust, whatever they called it, is a legislative body.
Well, let's assume for the sake of argument that it is, Your Honor.
Okay. Because if it's not, that's the end of the case, correct?
I agree with that, but there are two equally compelling and independent reasons here why there's no petitioning and why Bayside failed to carry its threshold burden under Duracraft. The first one is what Your Honor just asked me to assume, namely that this is a legislative body. We obviously contest that. Secondly, Your Honor, it's what gets said, what the targeted activity is here. Now, Bayside, at this point in time, under the statutory scheme, had a narrow anti-solicitation provision that was designed to protect it. And it basically said when the BCEC goes into business, there aren't going to be gate shows, and to the extent that there are going to be shows that were formerly at these other sites, you can't solicit them. That's what the legislature chose. Here, the Bayside went to the South Boston Community Development Foundation, the entity that was going to sponsor the show. They were talking about an anti-solicitation provision.
Mr. Cooper, isn't it right in Judge Lang's opinion that it was the foundation that invited Mr. Corcoran to come talk about the law? Doesn't she say that?
Two separate things, Your Honor. The anti-solicitation provision had to do with the lack of solicitation of my client for shows. It's contested in the record as to who initiated these private meetings. The first one at City Councilor Jimmy Kelly's office at City Hall, and the second one at Mull's Diner in South Boston in March of 2005. The fact that politics may be in the air, Your Honor, is irrelevant to the analysis here. The cases have held that.
No, my point
But-
only is this, that at least as I read her opinion, that is the appeals court opinion, it seemed to be the fact as determined, I mean, as stated by the appeals court, was these were meetings that the foundation asked Mr. Corcoran to come to. So this relates to the Chief Justice. So what's being talked about may devolve into other things, but it's hard to say that, I think on this record, that Mr. Corcoran is pursuing them, A, and B, pursuing them for a purely anti-competitive reason.
Please, Your Honor, if you read Mr. Corcoran's own words as described in his first and second affidavit, that's exactly what he's doing. Mr. Corcoran is not there saying, remember, first off, this is not the South Boston Community Development Corporation's or Fund's statute. It's not an enabling statute. They don't interpret it. Nothing in the statute suggests that. They are there solely to compete by putting on 3 events. That was Mr. Corcoran's own words was, I talked to the businessmen. I told them why they shouldn't do business with North American. I told them that I didn't think that they were able to do business. There's no discussion in that, in those conversations, the 2 conversations about let's go to the legislature. I see the lights blinking. I just want to make 2 very quick points. If one looks at the July, the post-filing of the complaint, July 2005 letter to the Massachusetts Marine Trade Association, a 20-plus year vendor of my client, you will see that not only is it not mirror image of anything before the legislature whatsoever, but it is an outright solicitation of my client, of the NMTA, by, I'm sorry, of the customer by providing them with false information. It's classically tortious interference. Now, this court in Wenger v. Aceto parsed 2 of the 3 counts in terms of which counts were within and which terms were without the anti-SLAPP statute. I will tell you that for reasons discussed in our brief, each one of the counts is outside of the anti-SLAPP statute. But I would urge the court, the 10 years of jurisprudence since Duracraft make it clear that the threshold burden of the special movement is to show that the complaint is based solely on petitioning activity. Here, the activities that are at issue overlap in each count. We've argued in our brief, for example, how could it possibly be a violation of the anti-SLAPP statute to seek a declaration under 231A to have the Superior Court judge who hears it on a preliminary injunction at a time where my client was about to be put out of business by Mr. McLaughlin's client? We should make no mistake about the evil that was actually trying to be remedied in this lawsuit, to use his word. But at that, how could it be a violation of the anti-SLAPP statute for a party to avail itself of a statutory right to come to court to get clarification of the rights in a dispute between the parties? And each one of the counts is based upon conduct that is well outside of the anti-SLAPP statute. But most importantly, the reason for...
Mr. Cooper, you are now way over.
I'm sorry, Your Honor.
Okay.
Thank you.
We'll take a short break. All right.